Thank you. Good morning, everyone. Good morning to everyone here in Carson City, as well as those in Las Vegas, and of course, anyone watching online, either through Nellis or our YouTube channel. Committee Secretary, will you please take the roll?
Assembly members Cole. Here. Dahlia. Here. Gonzalez. Here. Gray. Here. Hanson. Here. Hardy. Here.
Okay,
LaRue Hatch.
Here.
Marzola.
Present.
Moore.
Here.
Nadeem.
Present.
Ortlicker.
Here.
Roth.
Here.
Urick. Here. Chair Miller.
Here. And it looks like everyone else is as well. Just a few housekeeping reminders. Please turn off the sound on any of your devices. Also, the agenda is available on Nellis, where you can also locate the phone number for today if you need to call in to testify on a bill or to make public comment. We will have public comment at the end of today's agenda. The phone number today is 1-888-475-4499, and the meeting ID is 839-4825-1627. Again, we ask that public comment and testimony be kept to 2 minutes each. We also ask that presenters keep their bill presentations to 15 minutes each. And with that, I think we're ready to begin. So I will open up the hearing for our first bill today with Assembly Bill 88. Assembly Bill 88 revises provisions relating to juvenile justice. And so I will give our presenters a moment to get settled in. Please introduce yourselves. Also, please say your name and spell it. The first time you say your name, spell it so that we have it accurate in the records. And whenever you are ready, please proceed.
Good morning. My name is Catherine Marr, Katherine, Marr, Maher. Here with Angela Knott from the Washoe County Public Defender's Office. I am a youth defender with the Washoe County Public Defender's Office. Here to present on behalf of AB 88. It's a fairly straightforward bill that requires, I think, some explanation as to the juvenile process. The elevator pitch of the changes requested in AB 88 are essentially to give the juvenile court the discretion to dispose of a juvenile case using informal supervision. That requires an explanation of what informal supervision is. So first off, Title V is the collection of laws that govern the juvenile system. One of the stated intentions of Title V is to create programs that are designed to prevent a child from becoming subject to the jurisdiction of the juvenile court. At least in Washoe County, informal supervision is really the heavy lifter in that regard. It's where our kids are sent and dealt with in order to keep them from entering the juvenile system, the juvenile delinquency system. Informal supervision specifically allows a youth to participate in the juvenile system in the least invasive way possible where that's appropriate. For example, juvenile services, if they were to receive a citation from school police that a youth had gotten into a fight while on campus at school, when a case is handled informally, juvenile services can work with that youth and the family to complete certain sanctions and access resources in the community. For an example like that, youth gets into a fight on campus, they might do community service, they might participate in a youth development program like anger management, they might write a letter of apology, They might get referrals for counseling out in the community. All of that can be done through the informal system with a case manager without entering into the formal legal system. Through those means, the child isn't integrated into that official process unless necessary. So within that example, the process goes thus: citation issues, it's sent to juvenile services. Juvenile services then conducts a preliminary investigation or inquiry, which usually includes a meeting with the child and the family, and they make an assessment whether a youth is appropriate for that informal supervision. If they feel that the youth is appropriate, if the youth is in agreement, and if the youth is willing to enter a voluntary admission to the accusation, the case then can proceed informally. If juvenile services doesn't believe that the youth is appropriate for informal, they refer the case to the district attorney's office. The district attorney then determines if a petition is appropriate. Petition filing is what starts the delinquency process. That's where we come in. The way I explain it to my youth is essentially think of the informal process on the bottom level. Everything can be taken care of there. However, if a petition is filed, the kid is then going up the elevator onto that second floor, and that's where the lawyers come in. At that time, the formal court process begins. The youth is appointed a public defender in Washoe County. Public defenders are appointed to all youth. And then the guardian and the youth are issued a summons requiring them to come to that initial court hearing. So if we take that early example, a youth accused of getting into a fight at school, if they're charged with, say, a misdemeanor battery, and they admit to that charge in formal court, the juvenile court then has essentially 3 options available to them as to how to dispose of the case. Option 1 would be sending it back down the elevator, sending the youth down to that informal level. Through that, the petition gets dismissed. It's no longer in the formal setting, and the youth can complete sanctions as I outlined earlier. Option number 2 is called a supervision and consent decree. It's an agreement by all parties. And then option number 3 is the formal adjudication. That places a youth on probation. They may be subject to lots of constitutional waivers of their rights, and they may be subject to detention and remand if they're not following those rules of probation. So a big difference in the outcomes of the case. So again, misdemeanor battery, the court has all of those options available. Taking that same example, if the youth is charged with, say, challenge to fight, a gross misdemeanor violation of the law, same kid, same fact pattern, the court no longer has option 1 available. That's taken off the table unless the district attorney is in agreement with that option. That essentially leaves probation supervision and that invasive integration that I described earlier. Essentially what AB 88 does, it's not creating a new avenue of relief. It's not changing the informal process. It's not changing the adversarial nature of the court process. It's merely allowing the juvenile court in that context to have option 1 as a dispositional outcome in the case. This really only makes sense if you're viewing not only NRS 62C.200, but also NRS 62C.230. Those laws together are what give the juvenile court the ability to dispose of a case through informal handling. That statute reads that if the district attorney files a petition, the juvenile court may, subsection A, dismiss the petition without prejudice and refer the child to the probation officer for informal supervision pursuant to NRS 62C 200. So that's the statute that gives the juvenile court the ability to dispose of cases using informal handling. Because it references NRS 62C 200, the court has to follow the current writing of that statute. So by eliminating subsection B of NRS 62C 200, it's taking away the stamp of approval that the district attorney has to give to the court. We feel this is the proper, separation of powers, allowing the court to dispose of a case as it deems appropriate. This issue first really came to our attention around 2020, 2021. We were seeing a lot of vape cases, children coming in, they'd have one marijuana vape. It would be charged as a felony possession of controlled substance, and youth were having petitions filed, and then unfortunately often ending up on probation supervision with having to do random urinalysis tests, having themselves in their homes subject to search and seizure, a pretty invasive level of intervention for a youth who may have no other history. That was in part just due to the state's policy at the time. They took those cases very seriously, and they weren't willing to agree to informal handling in those matters, and so the judge's hands were often tied. We would find ourselves occasionally in situations where juvenile services was recommending that the case be handled informally. The judge would have otherwise ordered that, but the judge wasn't able to based on the current language of the statute. Now, I don't want to misrepresent. We have a very good working relationship with the state and juvenile services. That's no longer really the current policy, but it is what brought to our attention kind of the imbalance that could occur with the statute written as is. So again, I just want to emphasize, with this change, a petition gets filed, district attorney has the ability to charge it however they feel is appropriate. We come to court, the youth is provided with representation. Juvenile services then does assessments. After the youth the juvenile services does assessments. They have something called a YLS, which determines risk level, and they give recommendations to the court. All of that would still exist. So the court would be provided all of that information about the charge, about the youth. The state would be able to make their argument for whatever they felt was appropriate. The defense would be able to as well. But it empowers the court to send that youth back down the elevator where it's appropriate. That's really the basic idea of the request. I'm happy to take questions as to the juvenile process or the impact of the bill. But really our goal is just to free the hands of the juvenile court. Thank you.
Thank you. And we do have a few questions that will be focused just on the bill and whatever's related to that. We'll start with Assembly Member, excuse me, Gray.
Thank you, Madam Chair. Couple of problems that I have with this bill is, first, we're removing the DA from the, his office from the process. He was the one elected to handle, these things, especially when we're talking about gross misdemeanors and felonies. I just, if kids charged with gross misdemeanor or felony, I don't even see unsupervised probation as being shouldn't even be an option. Misdemeanors, yeah, it's a little bit different, but I think we are removing one of the checks and balances of the system, and I don't think it's good for defendants or the public. Is there another way that is being proposed to have oversight to make sure that the system is going to work?
Catherine Marr, for the record, I don't believe that the district attorney is being removed from the system. Essentially, how the process works is that at the informal level, juvenile services is referring cases to the district attorney. Juvenile services is a court kind of law enforcement hybrid body. They have lots of policies on when they feel it's appropriate to keep a case and when they don't, even outside of this statute. So for example, where there's a large restitution request, we'll always see a petition on that, regardless of the nature of the charge, because that's something that requires the supervision of the court and the protection of the rights afforded by the court system on both sides. There's a protection written into Title V, NRS 62C.100. It actually allows where a case is handled informally, the complainant can be notified or should be notified, and if they don't believe that's appropriate, there's a ability for them to contact the district attorney's office and have the case reviewed. So the district attorney can then determine if a petition can be filed. So certainly in a case where maybe juvenile services does their full assessment, they review the police report, they interview the family, they rely on all of the tools that they have available to assess risk level and what a youth what consequence they should have in that situation. The complainant can still contact the district attorney's office and ask for that relief to be changed into a petition request. Furthermore, there's a time window, essentially, that the juvenile has the opportunity to complete those sanctions. So, for example, if they're not getting everything done, or they were to pick up a new referral showing that they may be a higher risk than was initially assessed, petitions get filed, requests are made. I think that the juvenile system only works if we have some faith in juvenile services and their level of expertise. They're the ones who run the assessments, have the child behavioral, knowledge in addition to that law enforcement capacity. They're the ones supervising the youth. They see the patterns, and they have the ability to refer for petitions when they feel that the informal handling is not appropriate. So I think there's catches built into the system, pre-petition. Post-petition, the district attorney has filed the petition. They're in court. They know what's going on. They have the ability to advocate for a myriad of outcomes. Often we're in court jointly requesting informal handling. I think it's important to, really, this is a narrow set of cases where everybody would be on the same page. Juvenile Services is generally not recommending informal handling for a youth that's exhibiting very high-risk behavior, violent offenses, and, even if that were recommended, we have the safeguard of the judge. But the district attorney is very much involved in that court process and advocate zealously for whatever outcome that the state feels is appropriate, regardless of this law change.
Thank you. And you also answered one of my follow-on questions about victim protection. They get a voice in it, and hopefully the DA and the judge would listen to them before executing any kind of informal supervision. So thank you, Madam Chair.
Thank you for that. Our next question is from Assemblymember Urick.
Thank you, Chair, and thanks for the presentation this morning. I think I understand what you're trying to do, but I'm going to be honest with you, I'm really surprised because if I'm understanding this correctly, there might actually be scenarios where a juvenile is brought in and arrested for a gross misdemeanor or a felony, and that under this program, without representation or review by a district attorney, that there are even if there's sufficient evidence to bring actual charges, you could have a juvenile admitting a gross misdemeanor or felony. That seems to create a challenging situation that normally I wouldn't see you advocating. Are you really okay with that?
Again, I think we have to take Title V as a whole. There are offenses that are highlighted in Title V as being inherently more serious. So, for example, there are a list of sexual offenses that if a youth is adjudicated, there are really significant consequences involved. Again, I have faith in the juvenile services that they're not going to be asking for those cases to be handled informally. Part of what juvenile services does in their process is they advise the youth of, I guess not advise, that's not a correct word since they're not attorneys, but they explain to the youth that if they admit that they can move forward informally. If the youth doesn't want to admit, if they express really any discomfort, if they just say they want to talk to a lawyer, Juvenile Services refers the petition to us. This is actually something we see quite often. For example, a youth might be charged with something more serious or they are confused. This happened a lot when the vape cases were being charged as felonies. They were very afraid that they would have a felony on their record, and so they would ask to speak to an attorney. At that point, again, the petition is filed, we get assigned, the youth has the opportunity to speak with us, and we can negotiate on their behalf. An example that, supports this change would be a youth is involved with Juvenile Services, they're charged with a misdemeanor, they say, I don't get it, I want to talk to an attorney. A petition is then filed, and they come to us, and then assume it's a gross misdemeanor, not a misdemeanor. They come to us, a gross misdemeanor has now been filed, they're in the delinquency system, and even though they just wanted to talk to an attorney, we can't get them back down into that informal setting if the state is not in agreement. So I think everything on balance, Juvenile Services is very adept at assessing community risk and community safety. it is better for a youth to handle a matter informally, even if it's showing on their juvenile history as a felony or gross misdemeanor, at an informal level, because it's not a formal case. It's never made it into the formal arena, so it's not identified as a felony or a gross misdemeanor, if that makes sense. It's shown as no petition filed, they completed their sanctions. We know that there's not going to be necessarily large collateral consequences, because if there were going to be large collateral consequences, those are codified in statute for the most part. Juvenile service is going to request a petition on those cases.
Thank you so much. Our next question is from Assemblymember Roth.
Thank you so much, Chair, and thank you for the presentation. The juvenile court system is something I think most people don't understand, so that was a very thorough description of the process. If you could just dumb it down a little bit for me, I guess I see it kind of analogous to a regular sentencing hearing where the prosecution could say, we want prison time or we want jail time. The defense could say, we want probation, and the judge gets to decide whether or not there is a lesser or greater sentence. And the way I'm understanding it, it's kind of like that before you get to the formal setting, so that the judge does have the discretion where they did not have it before. Am I understanding that correctly?
Catherine Marr for the record. Can you repeat your question?
Yes, and I'm sorry. So my understanding is that basically this gives a judge discretion prior to a formal filing to do a lesser, like to do an informal, right? Is that correct?
Catherine Mark for the record. No, informal exists on a whole other level than the court process. So what's happening on the informal level is that juvenile services is assessing the youth. The formal level occurs once the petition is filed, and that's when it occurs very much like a sentencing. The informal level does require an admission. The youth has to agree that they did commit this act. On an informal level with juvenile services, they then enter into essentially a contract whereby they complete some sanctions, and that is without a petition ever being filed. That's totally outside of the court proceeding. If a petition files, then yes, the process is very much like a sentencing. And that's where NRS 62C230 is allowing the judge to use informal handling as a dispositional outcome.
Just briefly, I'm just trying to get at it. This is giving a judge discretion at the initial stage in the proceeding, correct?
After the petition, correct.
Thank you for that brief response. Next question will be from Assemblymember Hanson.
Thank you, Chair. Thank you for being here. I'll do this little looky-loo around. So regarding that the DA has right now, the way the process plays out is the DA has the ability to make a decision on how this is going to, whether or not they have that ability to go to more of an informal. Do I have that right?
The district attorney has the ability to file a petition.
Oh, okay, that's the terminology I was looking for. Thank you. I'm curious, how often does the DA say no? Like, how big of a problem is this that they don't do that? I'm sure there's opportunities where they do. Just curious if you even just have a guesstimate, how many times do you ask and maybe it's no?
So if a petition is filed and the district attorney doesn't approve in the court setting, I don't have numbers on that. As I indicated before, it's fairly rare. This is a small number of cases. In most cases, it's very clear, if a youth is tracking to a higher level of supervision, and that's where the case is going. If the case is handled informally, I think there's a very small middle area of cases where it hinges one way or the other. Again, what brought our attention to this issue was that large number of cases, those vape devices, where it was something relatively minor, but based on a policy, we were seeing a large number of cases that were being entered deeper into the system, not necessarily the way that the judge or juvenile services would have recommended on their end, not just, our advocacy. So to be candid, I would say it's a relatively small number of cases, but they are the cases where it's a knife's edge, right? There's very obviously youth that needs to be on probation, supervised. We have a vast array of consequences that can be imposed in those situations. And there's youth that very obviously need to just stay in the informal setting. This is the youth who is right on the edge, and we are looking at Title V as a legislative, the legislative intent is to provide for this opportunity to keep a youth from being unnecessarily integrated deeper into the system. So we just are asking for that decision to be made by the judge, to look at the full picture of the youth, the full picture of the charge, the full picture of the juvenile's history, the testing done by juvenile services, recommendations from evaluations, all of that, and just allow the judge to be the one to make the decision in those kind of edge of the knife situations.
Remember, we have a few more questions still, so if I could make the rounds just for timing, because we still have two other bill presentations, so we need to keep moving along. And then you could always ask that offline. Thank you. Our next question will be from Assembly Member Cole.
Good morning, thank you. So my question is, you had mentioned that if the complaint, or if the DA decides to go the informal route, doesn't file the petition, the complainant is notified of that and they have the opportunity to petition the DA to go the formal route. My question is it the same if the process is that the DA files a petition, the case goes to court, and the DA agrees with the court to take it down to informal? Does the complainant get notice again there, or is it just when the DA makes that initial decision?
Thank you, Catherine Marr, for the record. My understanding is that the district attorney's office follows the general notification process. Victims are notified of the hearing. Technically, juvenile matters are open court, so victim can participate if they're present. The judge gives them the opportunity to speak last, same as in the criminal context. And so yes, if they are participating, they are aware of that process and can give their own feedback to the court.
Thank you. Our next question is from Assembly Member LaRue Hatch.
Thank you, Chair. Thank you for answering our many questions today. I noticed that it says the child has to voluntarily admit participation in the acts, and then further down it says they have to voluntarily enter into an agreement. So if they don't admit the acts or they don't want to enter into this agreement, they just go through the formal court process. Is that correct?
Catherine Marr for the record, that's correct.
That's all I needed. Thank you.
Awesome. Thank you so much. With that, I think Assembly Member Gray, you have a yes or no question as well?
Yes, ma'am. Yeah, simply yes or no. Will you guys delineate what categories of felonies would be eligible for this informal probation? You know, A through F. I mean, will those be delineated? Just yes or no?
Catherine Marr for the record, I don't believe in statute. There may be policy within juvenile services, but I don't believe in statute there would be a specific delineation.
Okay, thank you. And with that, we will go ahead. I don't see any more additional questions. Thank you for the presentation. We'll go ahead and open it up for testimony. Again, just a reminder, anyone making testimony, please make sure that you say your name and spell it for the record, as well as keep your comments to 2 minutes, please. So we will start first here in Carson City, and then move to Las Vegas, and then to the phones.
Good morning, Chair Miller and members of the Assembly Judiciary. Paloma Guerrero, Paloma Guerrero, Clark County Public Defender's Office. We support this bill. It allows judges to have all options on the table to do what's best for the youth. The state will still be able to advocate on their position, but the judge can look at the full picture and make a decision themselves. Thank you.
Is there anyone else here in Carson wishing to make public comment? Is there anyone there in Las Vegas? Not seeing anyone. Broadcasting, will you open the lines?
If you would like to testify in support of Assembly Bill 88, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 963, please press star 6 to unmute your phone. You may begin.
Hello, good morning. My name is Yesenia Moya, Yeseniamoya. I'm calling in support of AB 88 today. It is a legislation that a lot of us do support, and we encourage the members to also support as a way to continue to support our youth in all the ways that are necessary. I do believe it's common sense. And I am grateful for the folks that brought this bill up. So please.
Thank you so much. Next caller.
Chair, there are no other callers to testify in support at this time.
Thank you. Then I will open it up for opposition testimony. If there's anyone here in Carson City that would like to oppose Assembly Bill 88. Not seeing anyone. But I do see someone approaching in Las Vegas. So please proceed with your testimony.
Good morning, Chair Miller and members of Assembly Judiciary. I am Bridget Duffy, BRIGID, DUFFY, Assistant District Attorney for the Juvenile Division of the Clark County District Attorney's Office. And I am entering opposition on AB 88 on behalf of the Nevada District Attorneys Association. AB 88, I have 2 minutes, so I could probably find some time, I hope, to talk to you, because I believe there is a lot of confusion I'm hearing with our system and how this works and how this will be impacted. But AB 88 is in general seeking to remove the voice of the community and victims from charging decisions we are making on felonies and gross misdemeanors in our states, as well as input on dispositions, what we call sentencing in the juvenile system. This bill is not reducing sentencing on crimes or deciding that juveniles shouldn't be charged with certain offenses. The bill is saying the community no longer needs the district attorney's office to review gross misdemeanors and felony charges to determine if there is evidence to file the case before deciding the consequences of the child. I think there's conversation about judicial discretion, and there's the process that happens before a case even goes to court. So this bill does 2 things. There will be thousands of cases in Clark County of felony and gross misdemeanor referrals that will never see a judge now. because they can be handled directly by the Department of Juvenile Justice Services. So that has nothing to do with judicial discretion. That is the discretion of a probation officer to, one, decide what I went to law school for, whether or not there's enough evidence to even charge the case, and then two, have the child admit to that felony or gross misdemeanor without the assistance of counsel, and to be then put on informal probation. That's tons of cases, thousands of cases in Clark County. Then if the case somehow gets to the vision of the district attorney's office and we file the petition, then you're talking about this bill would also give the court some additional discretion to refer the case back to informal supervision. So there's two very big issues there. One is thousands of cases that will never see DA review, and the other is the handful, as testified to by the Washoe PD's office, that may make it to court where they want to make sure the court, over the district attorney's consent, has the discretion to send it back. So I'm going to give you an example of a current process in Clark County: gross misdemeanor battery on a protected person. That's a battery on a teacher or an administrator, a nurse, a police officer, among other protected peoples. So a charge where a student or hits a teacher or an administrator, currently school police routes that to Juvenile Justice Services. Juvenile Justice Services, under the current 62C-200, would then send that gross misdemeanor to the DA's office. The DA's office would review for evidence and determine whether or not to file the case. If we determine not to file the case, we kick it back to juvenile probation, who then can put the child on any informal probation that the child would qualify for. So that's the current process in Clark County. It works. It's a checks and balance system. It is what the bill is doing right now. If passed, would be the opposite of a balance system, because it would take out the elected official
Ms. Duffy,
for the community.
we are.
So I know I have 2 minutes.
No,
I would offer to-
yes.
Yes, Chair Miller, I'm sorry.
Yeah, we're way over time, so.
Yes, I'm sorry. I appreciate for the overtime, because this is my first appearance and I've just missed you all. And I would say, if you would like to continue to discuss this bill and the role that our office plays for victims in the community, I would invite you to contact me. And I thank you for your time in my opposition to AB 88.
Thank you so much. Is there anyone else there in Las Vegas wishing to make testimony? Not seeing anyone approach. Broadcasting, will you open the lines?
If you would like to testify in opposition to Assembly Bill 88, please press star 9 now to take your place in the queue. Follow with the last 3 digits, 044. You are unmuted and may begin.
Hi, my name is Desiree. I'm actually here in support, but my phone was just not working. But I'm a community organizer focused on youth. I do support AB 88 for the most part.
Okay,
a
ma'am.
first-time offense often leads to a cycle of system involvement for young people.
Ma'am, I need,
Black and
excuse
brown
me.
youth are disproportionately incarcerated, as shown by the 2023 Clark County Juvenile Justice Services report, where 53% of cases filed by the DA were for Black youth, despite them only making up 13% of the youth population.
Okay,
So
ma'am,
it's very
can
clear
you
that
hear
the
me?
DA's office is
She must have
disproportionately
a button or
filing these
something.
cases. This bill offers a second chance to marginalized communities for true rehabilitation. We should advocate for the least invasive interventions. I also
Okay, ma'am,
note
I have a
that
question for
we are
you.
hearing these bills impacting the youth while they are in school, so they are not able to speak on their own behalf. So I also just want to emphasize that to the assembly members and just folks who are testifying. These youth are not here to talk and speak on their behalf. So I just want to put that out there. Thank you.
Okay, ma'am, can you hear me? Hello? Did we get her name? I'm asking the committee secretary. Okay, so you got her first name, no last name.
Also, ma'am, I have a question for you.
Okay, I'm not sure who that is. Okay.
Hello? I can't hear you. I'm sorry.
Is this Desiree?
Hello? Yeah, I can hear you. Now I can hear you.
Okay, thank you. Ma'am, I need you to say your name, first and last name, and spell it for the record. Also, I want to ensure.
Yes.
Okay, and
I'm
also,
sorry.
I want to ensure that your testimony is in support. I will allow a support testimony, but you made a comment about I mostly support it. And in order for it to be a support testimony, you have to 100% support the bill as written. So
Okay.
do
My
you,
name is Desiree.
go ahead.
My name is Desiree Smith, DESIREE SMITH, and I do fully support it. Yeah.
Okay, perfect. Thank you so much. Next caller.
If you have recently joined and would like to testify in opposition to Assembly Bill 88, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in opposition at this time.
Thank you. Then I'll open it up for neutral testimony. If there's anyone here in Carson that would like to testify in neutral. Not seeing anyone. Is there anyone there in Las Vegas? Broadcasting, will you open the lines, please?
If you would like to testify in neutral for Assembly Bill 88, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in neutral at this time.
Thank you so much. Then with that, I will go ahead and, are there any brief remarks that the presenters would like to make? Are the presenters still here? Oh, no? Okay. Thank you so much. All right, then I will go ahead and close the hearing on Assembly Bill 88. Next on the agenda is Assembly Bill 89. So I will open the hearing and give our presenter, Assemblymember Gonzalez, and whomever she's presenting with, a few minutes to get settled. Thank you so much.
Good morning. Thank you, Chair Miller and members of the Assembly Judiciary Committee. My name is Assemblymember Cecilia Gonzalez, and I represent Assembly District 16 in Clark County. Today I'm here as a member of the Joint Interim Standing Committee on Judiciary for the 2023 to 2024 interim to present to you Assembly Bill 89, which aims to regulate the use of unclothed searches in juvenile justice systems by establishing procedural safeguards and limiting their use to extraordinary circumstances. At the April meeting, the committee received a presentation and recommendation from Jennifer, Chief Deputy Public Defender, who's also with me here today, in the Juvenile Division, in the Clark County Public Defender's Office to address existing practices related to juvenile detention and treatment. These discussions revealed the need for greater oversight and standardization of procedures involving unclothed searches to ensure the safety, dignity, and well-being of children in our care. This is particularly important to implement in the juvenile justice system, as unclothed searches can be significant triggers for victims of sexual abuse, and statistics show how many youth involved in this system are victims prior of abuse. Assembly Bill 89 directly addresses these concerns by promoting clear and consistent policies regarding when and how unclothed searches may be conducted in regional facilities for the treatment and rehabilitation of children, local facilities for the detention of children, and state facilities for the detention of children. This bill amends provisions concerning local, regional, and state facilities for detention or commitment of children to ensure comprehensive coverage across all relevant juvenile justice systems. Any unclothed searches that do occur under these limited, extraordinary circumstances must be conducted with the physical presence of at least 2 employees of the facility for the entire duration of an unclothed search, which provides a safeguard against potential abuse or misjudgment. The employee primarily responsible for the unclosed search must submit a detailed written report to the administrator or director of the facility within 72 hours, ensuring transparency and accountability. And lastly, these reports must include a description of the search and any other information requested by the administrator or director, allowing for a thorough review and oversight. I will now kick it to Jennifer if she has any final comments, and then we will take questions. Thank you so much.
Good morning, Chair and members of the Judiciary. Jennifer Fraser, Jennifer, Fras as in Sam, ER. I just want to echo everything Assemblymember Gonzalez just presented. Our focus was to protect children in our facilities, both local and statewide, because unclosed searches are extremely invasive and intrusive for especially for adolescents. It re-traumatizes potential sexual abuse survivors. And I do want to recognize that this is something that the American Bar Association came out with a proclamation several years ago encouraging all state, local, municipality governments in working on these types of bans. Our facilities throughout the state, I think most, if not all, have policies in place, but I think this bill ensures that there's consistency among all of the facilities for all of the children throughout the state of Nevada, and limits when and how searches are undertaken. Finally, I would note that there have been some juvenile justice stakeholders that have reached out with some concerns, but I think that we'll be able to definitely reach a consensus with this as well. Thank you. Thank you.
Thank you. And you're open for questions
Yes.
now? Okay, we will go ahead and begin with Assemblymember Roth.
Thank you so much, and thank you for the presentation. My question is in regards to the having two people present for the search. I'm wondering if there has been consideration of having a preferred gender in that scenario. I just imagine, being searched as a teenage girl, I would prefer to have two women present versus two males.
Thank you so much for the question, Cecilia Gonzalez, for the record. I think that can be taken into consideration. What I will my mic got turned off. What I will say is working on other
When I turn mine off, yours goes off.
That's so weird.
Technology. Okay, keep going.
Some asking for specific genders is that sometimes facilities are short-staffed and they may not have that specific gender. So there was a piece of legislation that I worked on last session where we included language that said that requested that if it was available, so it wasn't mandated. And so I definitely understand that concerns, and I agree with you, and I think that's something we could work on. But if folks are understaffed and they only have male officers, we would still want two folks there to be able to kind of address what we're trying to address. Thank you for the question.
Thank you. Our next question is from Assemblymember Dahlia.
Thank you, Chair, and thank you for your presentation. I just have a clarifying question about the phrase extraordinary circumstances. Is that defined anywhere in statute or in jurisprudence such that we have a touch point for how that's going to be interpreted? Thank you.
Thank you so much for the question, Cecilia Gonzalez, for the record. I don't believe it's defined in statute, and so that's definitely something I could get back to you on, Jennifer, if you wanted to clarify as well.
Jennifer Fraser for the record. It's not, and I agree that could be a potential issue, so I think that's something that can be worked on to satisfy all parties.
Thank you. Our next question is from Assemblymember Cole.
Thank you, Chair. So my question is related to the description of consistency, that we need to have consistency across the different facilities and whatnot. My understanding is that the additional staff being present during unclosed searches of youth is already a part of state policy, maybe not NRS, but state policy. So what facilities are not doing that currently?
So we have, Jennifer Fraser for the record, there are state facilities where children are committed to DCFS, and there's also local detention facilities, as well as rehabilitation facilities such as Spring Mountain Youth Camp in Clark County. So each division and each even like Spring Mountain Youth Camp's procedures for searches is different from the detention facility, and that can change at any time based on who the director is. So I think it's important, it was our goal to have this codified in statute so it remains the law and doesn't change whoever's in control. Thank you.
Thank you so much for the question, Cecilia Gonzalez, for the record. I would also like to add too that this does make it NRS, so they have to follow the law right now. You know, sometimes policies don't always get fulfilled, especially if we're short-staffed or anything. So this will make it so that it is a priority for people to make sure that they're following at all juvenile facilities. Thank you.
Go ahead, please.
Carly Okrent for the record. I just wanted to clarify that existing law in NRS 209362 requires certain policies to be adopted. That provision is applicable to NDOC facilities, and so what we're discussing here is in Title V, so these are different types of facilities.
Thank you so much. Our next question is from Assemblymember Gray.
Thank you, Madam Chair. In running a facility like that, I think first and foremost, our primary responsibility is protecting staff and other folks that are in the facility. How does this go to protecting other folks? I mean, there are ways to get weapons in, there are ways to get drugs in, and you know, I understand there's, you know, you could have somebody that, you know, may feel like they're being re-victimized, but for the greater good, I think we need to keep that in mind. How do we stop it?
Cecilia Gonzalez for the record. Thank you so much for the question. So I think actually having 2 officers does address that concern as opposed to 1 officer. If a child does have a weapon or some type of contraband, having 2 officers, number one, you can tackle that issue better than if it was just yourself. That I think that does address the safety concern. And also, yeah, I'll leave it at that. Jennifer, if you have anything you would like to add.
Jennifer Fraser for the record. I think when we're talking about that particular issue, I thank you for the question. It's always a balancing test between weighing the interests of safety and weighing the interests of the rights of the child, or specifically like when a child's arrested and brought to a detention facility. They continue to have constitutional rights. They're innocent until proved guilty. The rights against they're protected by Fourth Amendment. So I think when you're weighing both of those interests, that's why this isn't banning searches outright, but it's allowing for it in extraordinary circumstances when there's perhaps a probable cause that there is a weapon or that there is contraband being brought into the facility. So it's not an outright ban, but it's recognizing that that child maintains and retains Fourth Amendment rights and that there's still safety concerns.
Cecilia Gonzalez for the record. I also want to add this is in regards to completely unclothed searches. So regular searches will still take place. Thank you.
Understood. Yeah, it was. I mean, it was. The question was in regards to completely unclothed searches. You know, with the squat and cough and stuff like that. I mean, it's. Are you asking for a follow-up? No, ma'am. Thank you.
And these mics are screwed up. Yes, they are. And one thing I'd also like to, as someone who works with youth, is that professional protections work both ways. And so another way to view it is, as someone who works with students, I advise everyone to never be alone with a student, right? Especially in those situations where you have to make sure the door's open, but you're never really alone with the student. So I also look at it as it is protection for the officers as well against false accusations, because we know that's also a reality as well. So just wanted to add that extra layer, that it a little more protection for our officers as well. With that, question is from Assemblywoman LaRue Hatch.
Thank you, Chair, and thank you for bringing this issue. You know, as a teacher, I've had children describe going through these unclosed searches to me, and I think it's important for us to recognize that trauma. My question really was around the extraordinary circumstances, and so you may not have an answer right now. My question was just who determines whether it's an extraordinary circumstance? Is that something you contemplate adding in? Is that the officer? Is that statute? Who is the decider?
Cecilia Gonzalez for the record. Thank you so much for the question. I think that based on this hearing, that's definitely something that we need to consider and put in the bill and or NRS. That's a great idea, so thank you.
Okay. Our next question is from Assembly Member Urick.
Thanks, Chair. And thanks for bringing this concept. The idea of, I think, at the risk of speaking for all my colleagues, of standardizing this process is an interesting concept. But I'm going to just tap into what my colleagues have already expressed in this definition of extraordinary circumstances. And my question for you is, I understand that, I think in these juvenile facilities, especially down in Clark County when I was there a long time ago, they used wands to get weapons and things like that might come in. But one of the big concerns is bringing contraband in, that a lot of these wands will not get. And absent something like a strip search or other technology, it makes it difficult, and that can create a problem with contraband being snuck in. And so I would ask, are you considering including, suspicion of concealed contraband or drugs as part of that extraordinary circumstances definition? Thank you.
Thank you so much for the question, Cecilia Gonzalez. For the record, we will definitely take that into consideration and talk with stakeholders, as many members have brought that concern up. Thank you so much.
For sure. Yep. Thank you. Okay. I don't see any additional questions at this time. So I am going to go ahead and open it up for testimony. I'll also say this. We will start testimony and support. As you can see, we're having some issues with technology here, and I was just informed that it's going on throughout the building. So we will need to take a brief recess at some point. We think that they'll wait for us right now so that we can get through testimony, but they may not. So if we're told okay, now, just be prepared, it may be now, but let's proceed now, okay? So testimony for Assembly Bill 89. Please come forward.
Paloma Guerrero, P-A-L-O-M-A-G-U-E-R-E-R-O, Clark County Public Defender's Office. We strongly support this bill. Thank you.
Faster than the mic going off. All right. Anyone else here in Carson City in support of Assembly Bill 89? Anyone in Las Vegas? Okay, broadcasting, will you open the lines?
If you would like to testify in support of Assembly Bill 89, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of Assembly Bill 89, please press star 9 now.
Good morning, committee. This is Yesenia Moya, Y-E-S-E-N-I-A-M-O-Y-A. I'm calling in support today of AB 89. All our youth, regardless of where they are, regardless of anything they've done, deserve dignity and to be protected. And they deserve to be in spaces that are safe, especially if we do aim at rehabilitation or treatment. And despite some of the questions from members, I would like folks to remember that these are children, they are youth, and they do deserve that dignity that we all deserve, regardless of charges or wherever they're at in life. Thank you.
Thank you. Next caller.
If you have recently joined or would like to testify in support of Assembly Bill 89, please press star 9 now to take your place in the queue. You may begin.
Hi, my name is Desiree Smith again, DESIREESMITH. I'm a community organizer dedicated to supporting the youth. I do stand in support of AB 89 because at the end of the day, these are children, regardless of the alleged crime they committed. I personally cannot accept the idea of my little brother or my nephew being subjected to fully unclothed searches unless it's in quote-unquote extraordinary circumstances. Frankly, I really don't understand why some members are arguing in favor of this practice. The system is already traumatizing enough for the youth without adding further harm. Thank you.
Thank you. Next caller.
Chair, there are no other callers choosing to testify in support of AB 89.
Thank you. Then I'll open it up for testimony in opposition of AB 89.
Good morning, Chair Miller and members of the committee. Jeff Rogan, Jeffrogan, on behalf of Clark County. We have a limited opposition to this bill for reasons that you've already articulated today. We're concerned primarily with the definition or absence of a definition of extraordinary circumstances. Clark County has a policy on when unclosed searches can be performed. The standard that we use is reasonable suspicion. That's a standard that a lot of different states utilize. We think that's appropriate, and that's what we'd be looking for. We're also concerned about the absence of clarity regarding what consistency means between state and local law and state and federal law. Thank you.
And thank you for that. And seeing that this is an interim committee bill, I can speak for the committee because it's not an individual sponsor. We would be happy to sit down with you, and if you could provide that for us, we would be happy to do so. And I'd be happy to assign a list to that. So if you could work with her through that, we'd be happy to sit down with you on that.
I'd be happy to do that. Thank you.
Thank you so much. Anyone else in opposition? Not seeing anyone. Is there anyone in Las Vegas in opposition? Also not seeing anyone. Broadcasting, will you open the lines, please?
If you would like to testify in opposition to Assembly Bill 89, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to testify in opposition at this time.
Thank you. Then I will. This is like when we all first got cell phones, right? So I will open it up for neutral testimony.
Good morning, Madam Chair and members of the committee. For the record, Marla McDade Williams. I serve as the administrator for the Division of Child and Family Services. Put on record that we do unclosed searches, and we have policies in place to do that that are consistent with the Prison Rape Elimination Act. We do unclosed searches at entrance on admission to Summit View, as well as any time there have been unsupervised visits within the facility or with the approval of the superintendent when there is reason to believe contraband may be found. We have a policy that says unclothed body searches shall be approved by the facility superintendent or designee, conducted in private and based on a probable cause the youth is carrying contraband which threatens the safety and security of the facility. They are done by two-person teams, generally with the gender specified by the juvenile.
And also, if you would be able, Gonzalez as well, and I know the intention of all of us here are, multiple factors: the safety and security of the facility, the safety and security emotionally and physically of the youth. At no way did I feel at any time any member on this dais is condoning this, but, asking actual questions. And we also, this is where we appreciate and need input from the practitioners that do this every day. So when you all can get together so that we can improve this bill, it would be much appreciated.
Of course, thank you.
Much. Anyone else in neutral? Anyone in Las Vegas? Broadcasting, will you open the lines, please?
If you would like to testify in neutral for Assembly Bill 89, please press star 9 now to take your place in the queue. You may begin.
Good morning. My name is Elizabeth Flores, ELIZABETH and I am the Director of Juvenile Services in Washoe County. I am calling in the neutral position and look forward to shifting to the support position as we gain further clarification on the specific matters discussed in today's meeting. Thank you to the bill sponsors and presenters for addressing this important matter. Thank you.
Thank you so much, and I assume you've heard my comments about working with Assembly Member Gonzalez. You may not still be there, but okay, next caller.
If you have recently joined and would like to testify in neutral for Assembly Bill 89, please press star 9 now to take your place in the queue. Chair, there are no other callers wishing to testify in neutral at this time.
Thank you so much. I will welcome the bill sponsors back up for any final remarks.
Thank you so much, Chair. Cecilia Gonzalez, for the record. I just thank the committee for the insight, and I look forward with all the stakeholders in putting a working group together to get this across the finish line. Thank you.
Jennifer Fraser for the thank you for the opportunity to provide any insight. Thank you.
Thank you so much. And again, Assembly Member Gonzalez carried a similar bill to this for adult women in prisons with dignity and health. So I know that this is gonna do well. I'll get together in a working group. With that, I will go ahead and close the hearing on Assembly Bill 89. We are going to take a short, we are not on legislative time. We're not on floor time, we're on actual time. So 10 minutes. So let's come back at 9:25. We do have another. Yeah, they said it's all, watch what you say. Okay. I don't know. Okay, everyone, we're going to return. Apparently, we are back up and running. So with that, our next bill is Assembly Bill 90. So I will go ahead and open up the hearing for Assembly Bill 90. Give our presenters a moment to get situated. Please remember to introduce yourselves and to spell your name for the record. And when you are ready, please proceed.
Thank you, Chair, and members of the Assembly Committee on Judiciary. I am Assembly Member Cynthia Moore, CINTHIAMOORE. I represent Assembly District 11 in Clark County. I am pleased to present Assembly Bill 90, which aims to extend the Juvenile Justice Bill of Rights protections to children detained in regional treatment and rehabilitation facilities. Although I was not a member, this bill is a recommendation approved by the Joint Interim Standing Committee on the Judiciary during the 2023 to 2024 interim. During the meeting on April 26, 2024, Jennifer Frazier, Chief Deputy Public Defender, Juvenile Division, Clark County Public Defender's Office, presented to the committee on the need to amend the commitment process governed by Title V, Juvenile Justice of Nevada Revised Statutes. Revising the process for committing a child to a facility will ensure consistency in the statute by requiring the same findings be made for both a delinquent child committed to a regional facility for treatment and rehabilitation and one committed to the custody of a state or local detention facility. This bill directly addresses these concerns. Section 1 of the bill includes regional facilities for the treatment and rehabilitation of children within the definition of detention facility for the purposes of the Juvenile Justice Bill of Rights. This expansion ensures that children in these facilities receive the same rights, protections, and information as those in local and state detention facilities. This includes, but is not limited to, the right to be informed of their rights, receive a copy of those rights, and have those rights posted conspicuously within the facility. Section 2 provides that before the juvenile court commits a delinquent child to a regional facility for the treatment and rehabilitation of children, the juvenile court must make the same findings required for committing a delinquent child to a state facility for the detention of children. Assembly Bill 90 is the measured and responsible step toward ensuring the well-being of children within our juvenile justice system. By extending the Juvenile Justice Bill of Rights and reinforcing judicial oversight, we can better protect vulnerable youth and ensure appropriate placement decisions. I urge your support and welcome any questions. And right here presenting, ready to answer any technical questions is Jennifer Frazier, Chief Deputy Public Defender, Juvenile Division, Clark County Public Defender's Office.
Thank you so much. We do have a question from Assembly Member LaRue Hatch.
Thank you, Chair, and thank you for bringing us this quick bill. My question is just, could you give us some examples of what regional facilities for treatment and rehabilitation of children are in Washoe or Clark or any of our communities?
Good morning, Jennifer Fraser, JENNIFER, FRA, S as in Sam, ER. Thank you for the question. In Clark County, an example is Spring Mountain Youth Camp. In Washoe County, I believe there was China Springs. I don't know if it's still in effect, and I don't practice up here, but that's that would be under that statutory definition of regional facility. Just for some background, when kids are sent to a regional facility for the treatment and rehabilitation of children, that's usually about a 6-month stay. So it's an out-of-home placement. It's up and Spring Mountain Youth Camp is up at Mount Charleston. They're going to school, they have treatment, they can do work programs in the kitchen, forestry, but it is an out-of-home placement. It's so our request for this bill was the intent and the effect on the child is the same as if they got sent to a Department of Child Family Services like Caliente, Elko, or Summit View, which is also an out-of-home placement, which can be up to 9 months or longer. But here, the effect is the same, so we'd like the court to be making the same findings when they choose to send a kid there. Thank you.
Thank you so much. Our next question is from Assemblymember Ordlicker.
Thank you, Chair, and thank you for bringing the bill. I noticed in Section 1, local facilities are included, but they're not in Section 2. Are they picked up somewhere else?
Jennifer Fraser for the record. Section 2, NRS 60 deals with 62E.505, and that's a dispositional statute. So only when kids have gone through the plea process, have had a disposition after a statutorily required risk assessment. So essentially that's when the child is sentenced. So the court has to make that finding at the time of sentencing that there's no appropriate alternatives within the community or that they've already been tried and unsuccessful. So kids aren't sentenced to the local detention facilities. Thank you.
Thank you so much. Not seeing any additional questions, I will go ahead and open it up for testimony. Anyone here in Carson City that would like to testify in support of Assembly Bill 90, please come forward.
Paloma Guerrero, Paloma, Clark County Public Defender's Office. We strongly support this bill. Thank you.
Good morning, Angela Knott, Angela Knott, from the Washoe County Public Defender's Office. We support AB 90. In January, the Department of Justice found that the state of Nevada violated the Americans with Disabilities Act and the Supreme Court's decision in Olmstead v. LC. According to the Department of Justice, Nevada was unnecessarily segregating children with behavioral health disabilities in institutional settings like hospitals and residential treatment facilities. Nevada's children with behavioral health disabilities should have access to the services they need without being forced to leave their homes, their schools, and their communities. AB 90 is a positive and simple step in ensuring proper oversight before taking a child out of their home and forcing them into any facility. Again, we support AB 90 because it is appropriate to require a court to make a finding before any child is placed outside the home and in a facility.
Not seeing anyone else here in Carson City. Is there anyone in Las Vegas that would like to testify? Not seeing anyone approach. Broadcasting, will you please open the line?
If you would like to testify in support of Assembly Bill 90, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 963, please press star 6 to unmute your phone. You may begin.
Good morning, members of the committee. My name is Yesenia Moya, Yesenia Moya. I am calling and urging support for AB 90 as somebody who has seen countless family members and community members growing up, going to juvie when they should have actually gotten treatment, gotten help, seeing how them being separated from their family members made these situations worse. This is a form of legislation that will allow different avenues for our people to be and do what they would like to do in their life. Having a history of juvenile detention leads into high recidivism rates when you're an adult, and I've seen it within countless folks around me, my friends and family, just continuing the cycle. And so I think it's an important piece of legislation to ensure that we stop this where it starts. So thank you. Please support it.
Thank you. Next caller.
If you had recently joined and would like to testify in support of Assembly Bill 90, please press star 9 now to take your place in the queue. Chair, there are no other callers to testify in support at this time.
Thank you so much. Then I will open it up for opposition testimony here in Carson City.
Good morning, Chair Miller and members of the committee. Allie Bannister for the record, Alibannister. I'm the Chief of Juvenile Services here in Carson. I'm here to hopefully shift my stance to neutral, but I do have a few concerns. And so Section 1 of the bill adds a regional facility for the treatment and rehabilitation of children to the definition of a detention facility. Section 2 of this bill adds that before a juvenile court commits a delinquent child to the facility, the court must find that appropriate alternatives in the community were previously used and successful, and that a child poses a public safety risk. I am worried about the term delinquent used in this bill. Carson City, Story County, Douglas County, Lyon County, and Churchill County currently use the Western Nevada Regional Youth Center, which is a residential drug and alcohol treatment facility. Oftentimes, Carson City Juvenile Services will send a youth who is on a consent decree to this facility without declaring them delinquent. A child is sometimes allowed by the court to complete a consent decree. This is where the charges are suspended pending successful completion of their probation terms. On a consent decree, once completed, the charges will be dismissed. This is a good option and provides a reward for being successful in the program to the youth. This concept aligns with best practice in juvenile justice. If a child is required to be declared delinquent, as written in the bill, the youth will not have the option of their charges being suspended and dismissed after the program completion. I'm unsure if this is the intent of the bill, but it does pose concern with the proposed language as written. Thank you.
Thank you, and I will extend the same invitation to you as well, because again, this is a interim committee bill, so I can speak on behalf of the bill. But you are welcome to bring your amendments and suggestions to Assemblymember Moore. Thank you. Anyone else here in Carson City? Not seeing anyone? Anyone there in Las Vegas? Broadcasting, will you please open the lines?
If you would like to testify in opposition to Assembly Bill 90, please press star 9 now to take your place in the queue. Caller with the last 3 digits, please press star 6 to unmute your phone. You may begin.
Good morning. My name is Elizabeth Flores, ELIZABETH and I am the Director of Washoe County Juvenile Services. For clarification, I am in full support of the expansion of the Juvenile Justice Bill of Rights to regional facilities for the treatment and rehabilitation of children. My concern is that the mechanism to do so may have the unintended consequence of limiting access to the regional facilities by requiring courts to find the child poses a public safety risk as determined by a risk assessment pursuant to NRS 62E506 in the same manner that exists for commitment to state correctional facilities. In 2003, the Nevada Legislature created the designation of regional facilities for the treatment and rehabilitation of children and expressly stated that the term does not include detention facilities to recognize that regional facilities would provide treatment in a setting distinct from detention facilities. Currently, 62E506 subsection 2 requires juvenile services to prepare a report based on the risk assessment, mental health screening, and further evaluations if applicable. The report must identify not only the risk to reoffend, but also recommendations for the type of supervision and services the child needs. Sometimes the recommendation is for treatment, such as that provided by regional facilities for the treatment and rehabilitation of children. These facilities may serve youth presenting with substance use issues, those who have been victims of human trafficking, or those who require other general mental health supports. If courts are required to find that a youth poses a public safety risk, then youth whose prevailing issues are treatment-based rather than public safety-based may have limited access to regional facilities for treatment and rehabilitation. Again, I am in full support of the expansion of the Juvenile Justice Bill of Rights, and I'm available to discuss further if the bill sponsor and presenters find that helpful to gain clarification on the concern about potential unintended consequences. Thank you.
Thank you so much, and we do welcome those comments and suggestions. Next caller.
Chair, there are no other callers to testify in opposition at this time.
Thank you. Then I will open it up for neutral testimony. Anyone here in Carson City? Not seeing anyone. Is there anyone there in Las Vegas? Also not seeing anyone. Broadcasting, will you open the lines, please?
Chair, the public line is open and working. There are no other callers to testify at this time.
Okay, thank you. Then I will welcome the bill presenters up for any final remarks.
Thank you, Chair. Assemblymember Cynthia Moore. For the record, I'm looking forward to working with the stakeholders and coming up with an agreement and something that's workable for everybody. And thank you for this opportunity.
Jennifer Fraser for the record. I also look forward to working with other juvenile justice stakeholders. That certainly is not our intent to limit the ability for kids to go to treatment facilities, and I appreciate the time today. Thank you.
Thank you so much. I will go ahead and close the hearing on Assembly Bill 90. With that, next up we have public comment. So I will go ahead and open up public comment beginning here in Carson City. Not seeing anyone. Is there anyone in Las Vegas that would like to make public comment? Also not seeing anyone. Broadcasting, will you open the lines?
If you would like to provide public comment, please press *9 now to take your place in the queue. Again, if you would like to provide public comment, please press *9 now. Chair, there are no callers wishing to provide public comment at this time.
Thank you so much. Then I will close public comment, and we have concluded all of our business before us today. So I will adjourn this meeting and see you all tomorrow morning at 8 a.m.